Thank you for joining us this morning. My name is Treasure Mackley. I'm the Executive Director with Invest in Washington Now. We are a movement of educators, working families, and everyday Washingtonians united in support of a more fair, just, and equitable tax code. We have a great lineup of speakers today, but first, let me set the stage. Washington State has the most regressive tax code in the country, which means that those with the least pay the most. Lower and middle income folks oftentimes pay up to 18% of their income in state and local taxes, where folks at the high end of the income scale, the very wealthy, pay 3% or less. This is because for too long, our tax system in Washington State has relied on regressive taxes, like the sales tax, to pay for things that our communities need. But we've started to change that. In 2021, after over a decade and with the efforts of thousands of Washingtonians, the legislature passed the capital gains tax that will bring $500 million per year to fund child care, early learning, and K-12 education. Shortly after the legislation was signed into law, Quinn v. Washington was filed by a handful of millionaires and wealthy Washingtonians in Douglas County. The trial court in Douglas County ruled in favor of the millionaires behind Quinn on March 1st of 2022. The state of Washington and education intervenors are appealing the lower court's decision. The case, Quinn v. Washington, has now been picked up for direct review with the Washington State Supreme Court and is scheduled for oral arguments on Thursday, January 26th. This morning, we are going to hear from a panel of experts on the capital gains tax and the case before the Washington State Supreme Court. Then, after oral arguments on the 26th, we will have a press conference at the state capitol steps in Olympia at noon. So now, without further ado, we'll start with our first speakers. We'll go through our speaker lineup, and then at the very end, we'll open it up for Q&A. So I'd love to bring up our first speaker this morning, my friend and colleague, Andy Nicholas, Senior Fellow from the Washington State Budget and Policy Center. Andy?
Thanks so much, Treasure. As was said, I'm Andy Nicholas with the Washington State Budget and Policy Center. If you're not familiar with our organization, we're a nonprofit research and advocacy organization that focuses on building a stronger and more equitable state. So this morning, I'm briefly going to cover how the capital gains excise tax is structured, who will pay the tax, and how the tax will strengthen our communities. So what is the capital gains excise tax? Well, if implemented, starting this year, profits or gains from the sale of corporate stocks, bonds, and other financial assets above $250,000 per year will be subject to the new capital gains tax. Let me emphasize, no tax will be applied to capital gains below $250,000 per year. The tax rate on capital gains above $250,000 per year will be a modest 7%. In addition to the $250,000 standard deduction that I just mentioned, the tax will not apply to retirement accounts, sales of real estate, including family homes, sales of small family-owned businesses, and other assets held by ordinary Washingtonians. So only the wealthiest few will pay the capital gains tax. The tax will certainly help push back against rising wealth inequality in our state, and that's because only about 7,000 households, or roughly 0.2% of the population, will pay it. So again, the high standard deduction combined with exemptions on retirement accounts, all real estate, and other common assets means the tax will exclusively be paid by the wealthiest 0.2% of households. Furthermore, the tax will strengthen our shared commitment to dismantling the racial injustices that have divided our communities for far too long. And it will rightly direct new funding to rural communities that haven't received their just share of our state's economic pie. So our upside-down tax code means people who are Black, Indigenous, or people of color shoulder more than their fair share of the responsibility for funding schools, healthcare, and other important community structure. And the same is true for many of us who live in rural communities. Due to generations of unjust banking and economic policies, corporate stocks, and other financial assets remain heavily concentrated among a small group of extremely wealthy and almost exclusively white households. And these households tend to live in the most prosperous regions of our country, very much including the Seattle metro area. As a result, nearly 2/3 of all new revenues generated by the capital gains tax will come from wealthy households living in King County. Yet the new funding supported by the tax will benefit all Washingtonians, especially those who are Black, Indigenous, or people of color, and those living in rural communities. But unlike our state sales and property taxes, which can take a large bite out of ordinary Washingtonians' family budgets, the capital gains tax will exclusively be paid by those with extreme amounts of wealth. And these wealthy households can and should do more to support the common good. So the capital gains tax will strengthen our communities. As Treasurer mentioned, the law dedicates $500 million per year in capital gains tax revenues to our state education legacy trust account. This new funding will support childcare, early learning, and a range of other important community structures for kids and parents. Any revenues above $500 million per year will support the construction of new schools. Now, I'll certainly let Dr. Blanford speak in much more detail about the importance of adequately funding childcare and early learning. But from a high-level economic perspective, the benefits are beyond clear. Studies show that up to $12 in economic benefits will flow to communities for every $1 in increased funding for those structures. So just let me emphasize that. That's a 12-to-1 return on investment for communities as a result of the funding enabled by the capital gains tax. So just to sum it all up, the capital gains excise tax is smartly structured so that only the very wealthiest households will pay any additional taxes. By requiring the wealthiest few to pay a little bit more to support the common good, the tax will help address rising wealth, geographic, and racial disparities that continue to divide our state. And finally, the new funding for childcare, early learning, and schools supported by the tax will strengthen our communities and improve our overall well-being. Thanks so much, and I'd be happy to take questions during the Q&A portion of the event.
Thank you, Andy. Now I'd like to bring up our next speaker, Sharon Chen, who is a board member with Progress Alliance. Sharon?
Thanks, Treasurer. Pleased to be here and happy to see everyone. Again, my name is Sharon Chen. I'm here because my family is very fortunate and we will pay this tax. And I want to talk about why I support it, even though I will pay it. This is a beautiful state and one that I love. I came to this state almost 30 years ago, right out of college, attracted by the stunning landscapes, and because I got a job at Microsoft. I want to pay this tax because this state, my home, deserves strong public investment to not only preserve the things that all of us already find precious, like clean air and water, but also to have things like a first-class education for our kids, beautiful parks and common spaces, strong public health system, and resilience for our future. Just a few of the things that come from the investments, from the money that will be raised from this tax. These are things that make Washington State a wonderful place to live. At the same time, all of these things cost money. So I know the press briefing already tells us that this tax only applies to gains exceeding $250,000 in a given year. But I want to emphasize a point here so that people understand how modest this tax is. In order to have $250,000 in gains, think about how large likely the principal needs to be in order to have gains of that size. The people need to have held this principal for more than a year, which means they aren't using those funds for everyday needs. So I just want to give us a picture that we can understand about what we're talking about, what kind of tax we're talking about. I believe strongly that communities are stronger together, and this tax that just starts to address the income inequality that we have in this state, is part of being stronger together. Thanks. I'll pass it back to Treasurer.
Thank you, Sharon. Next, I'd like to introduce and bring up Paul Lawrence, who is a senior litigation partner at Pacifica Law Firm. Paul?
Good morning. Hi, I am Paul Lawrence, and I am one of the lawyers who will be arguing the capital gains tax case next week on behalf of a group of school districts, educators, and parents who will benefit from the revenue raised by the capital gains tax. The principal issue before the court is what is the proper characterization of the capital gains tax? Is it an excise tax? Is it an income tax? And if so, is that a property tax? The state legislature adopted this as an excise tax, and it bears all the characteristics of a classic excise tax, which is a tax that's imposed based on transactions, sales, for example, of stocks, sales of bonds, in this case, rather than mere ownership of property. So, for example, if you own property and sell it, you're subject to a real estate excise tax based on that sale. But if you own the property and keep it, you are subject to a property tax that's based on the assessed value of that property. So the question is this a tax on sales and transactions, which it undoubtedly is, because it captures, it is only triggered by when somebody sells stocks, sells bonds, or other qualified capital asset, long-term capital asset at a given a value of over $250,000 in a year. Now, there is a second question. The trial court held that this was not an excise tax and this was an income tax. If the court, that is the Supreme Court, holds that the excise tax is indeed an income tax, we raise the argument that the cases that go back to the 1930s holding that an income tax is a property tax under Washington law were wrongly decided and should be revisited and overturned. This simple reality of the situation is that the initial case that held that that's relied upon to determine that an income tax is a property tax was actually a case under the U.S. Constitution and a case that was subsequently overturned by the U.S. Supreme Court. So the basis for that initial holding is simply gone. And that holding has been wrongly characterized over the years. It's deciding that an income tax is a property tax under Washington law. But in fact, none of the cases go into an analysis of whether that is so. And we know that with respect to other jurisdictions and the federal courts, the answer has been that an income tax is not a property tax. The U.S. Supreme Court has recognized that, and almost every other state court that has addressed the issue has recognized that. So if the court holds that this is an excise tax, which we believe it is, that's the end of the case. If the court then goes on further to say, no, this is an income tax, we ask them to look at the precedent and take a fresh look based on current case law and current thinking and a correct understanding of the Washington Constitution to revisit the case law holding income tax is a property tax and hold that an income tax is either an excise tax or a tax unto itself different from a property tax, and on that basis uphold the capital gains tax. Thank you.
Thank you, Paul. Next, I'd like to bring up Hugh Spitzer, who is a constitutional law professor at the University of Washington. Hugh?
Thank you very much. As Paul mentioned, in 1933, our state Supreme Court issued a case that said that income is property. So an income tax is a tax on property, so it has to be uniform. This is a Washington state constitutional law issue. But very soon thereafter, within a couple of years, the court issued a case, an opinion, and has done so repeatedly, making it crystal clear that taxes on events and activity, those are excise taxes and not property taxes, just like the sale of real estate, where you pay a real estate excise tax that's a tax in connection with the event, the voluntary sale of the property. That's an excise tax. It's not a tax on the sitting real estate itself. With excise taxes like this one, and this statute was written very carefully by legislative staff to make it clear that it is a tax on the sale of certain capital assets. And the legislature has a lot more flexibility in the classes that it can create. It can have certain kinds of deductions it can't have with the property tax. Now, I wrote an article on the 1933 income taxes 30 years ago. I would be, and why they're wrong, and Paul's explained that. But while I'd be thrilled if our state Supreme Court were to overturn the 1933 case and expressly say that an income tax is constitutional, practically speaking, my guess is they're not going to do it. You never know. I don't think so, because it's very straightforward and really easy for them to recognize that this is a straight over tackle excise tax rather than some kind of a property tax. And in a sense, they don't really have a reason to make a constitutional decision. They simply can recognize that this statutorily created capital gains tax is an excise tax. That's an easy way for doing it. And then they don't have to enter the long-term controversy about income taxes and so on. So that's my hunch about what they're going to do, but you never know. Thanks.
Thank you, Hugh. Next, we'd like to bring up Howard Goodfriend, who is an appellate attorney and will talk with us about some of the amicus briefs. Howard?
Thank you so much, Treasurer. I am Howard Goodfriend. I'm with the firm of Smith Goodfriend, and it's been interesting to hear the speakers who've come before me and their characterization of the case. It really does, I think, illustrate and put in high relief the nature of precedent and the courts, as you know, and this has really been in the mainstream press in much more volatile context in the case of abortion and other fundamental rights. But appellate courts operate, based upon the cases that they have previously decided and honor their precedent. I'm proud to represent a bunch of law professors, including you, who's here today, who have basically analyzed the history of taxation under the U.S. Constitution and in the states in general, to illustrate the fact that in this distinction between excise taxes and property taxes, a tax on the receipt of income that's received upon the transfer of an asset falls squarely within the legislature's power to enact fair and equitable excise taxes to fund its residents' basic needs, to redress past economic and social inequities, and basically to allow the sound functioning of a modern state and economy. What our position is that there is some precedent in Washington for the fact that from the 1930s, and Hugh has talked about this, and so has Paul, about why this shouldn't still be the case, and why it was wrongly decided in the first instance. But I think that what the professors illustrate is you don't need to overturn this 1930s precedent, which, by the way, was decided under a time when property rights were really extolled well beyond human rights, and respect for property in all its forms really took precedent in the Supreme Court of Washington and the United States in their opinions. But that precedent deems the tax on, a broad-based income tax on income regularly received as a tax on property. And if it's not uniform, it's barred by the Washington Constitution. But of course, since that time, we've seen, and the professors demonstrate that this occurred in the United States as well, that what courts have distinguished between the receipt of income and a property. As Paul indicated, a tax on the value of property that you hold such as the property taxes you pay on your home, are a far different animal than a transactional tax on the one-time receipt of income upon the sale of capital gains. That falls squarely within the court's excise tax jurisprudence, and we believe that the court has basically upheld such taxes in the form of not only real estate excise taxes, not only sales taxes, not only estate taxes, which kick in upon the transfer upon death of assets, but in other contexts as well. And this tax, which operates only on the receipt of income on a transaction, is really not much different than a tax that operates on the receipt of income upon death or upon the sale of real property. So that's our position. We think that the Supreme Court is going to recognize that the legislature has broad authority to devise transactional taxes to fund its citizens' basic needs, as it's done under this legislation. Thanks, Treasurer.
Thank you, Howard. Next, I'd like to bring up Dr. Stephan Blanford from the Children's Alliance. Stephan?
Thank you, Treasurer. The Children's Alliance is an advocacy organization with over 6,000 members across Washington state who fiercely advocate for the interest of all of Washington's children, all 1.6 million children in every part of the suburban, rural, urban communities in our state. And we've taken a really strong position in support of the Fair Start for Kids Act that was passed in 2021 and is funded by the capital gains tax. As a result of the pandemic, an increasing number of disparities became apparent. One of the strongest disparities that we've seen was the number of kids who couldn't find access to high quality early learning. Whether you're thinking about early learning or K-12, both of those are essential in the future of the Washington state. And so we've taken a really strong position that Fair Start for Kids and capital gains as a result, both are in the interest of Washington state and its future economy and its citizens, and so are supportive of the capital gains tax as a result. One other point that I would make is that I spent a good portion of 2021 after the Fair Start for Kids Act was passed, speaking to advocates and providers in other states across the country who were amazed at what we did in Washington state in putting forth a progressive tax that has such profound impact in our K-12 and our early learning systems. It would be a shame for us to go retroactively back to a day when there was inadequate funding for K-12 and for early learning. And that's why we're hoping that the Supreme Court moves forward and endorses capital gains or validates capital gains as an appropriate approach to supporting these programs. Thank you.
Thank you, Dr. Blanford. And thank you to all of our speakers this morning. I'd now like to open it up for Q&A from the press. So if anyone has a question, if you can go ahead and raise your hand and we'll get to your questions. All right, now don't be shy. All right, Will Casey, go ahead.
Hey, thanks for hosting this presser this morning to answer our questions. My question's for Hugh or Paul, any of the litigators. Howard, if you want to jump in here as well. If the legislature, or if the court were to decide to overturn that 1933 precedent, what else could that sort of pave the way for in terms of further fixing the regressive tax code?
Well, I think that, principally it will give another tool to the legislature to take on alternative taxes that are more progressive, such as an income tax. There's certainly not going to immediately be any income tax that's imposed as a result of the case other than the capital gains tax if it's so characterized, but it will simply increase the ability of the legislature to address the revenue needs of the state, but in a fairer way to make sure that everyone's paying their fair share of taxes, unlike the current system.
And I think I'd add that we should be cognizant of the fact that Washington really is an outlier in terms of the small number of taxes it relies on. From a big time, it's property tax and B&O tax and sales tax. And I was on the state committee that was created 22 years ago or so, chaired by Bill Gates Sr., that looked at our tax system. And one of the things that we determined and put in our report was that most states, vast majority of states, have three-legged tool tax systems. They've got sales taxes, property taxes, and an income tax, a modest income tax. You look at Idaho, which is not known as a super liberal kind of state, but they have a very flat overall tax system in that regardless of income level, people pay about the same amount of their incomes in taxes. It is that, of course, that people who are wealthier are paying higher income taxes, and people who are poorer are paying more sales taxes because they spend all of their money. But it's real flat. It's real flat in California. It's flat in so many states, but we've got this huge disparity where the upper income people are paying maybe 3 or 4% of their income on state and local taxes. And at the low end, somewhere between 16 to 20% of people's income. So it would, if the court were to overturn the 1933 case, it would enable the legislature and the people to have a tax system that was more stable with lower sales tax rate, lower property tax rate, but then a modest income tax. Thanks.
Dr. Blanford, did you want to add something?
Yeah, I did. And I appreciate Professor Spitzer's comments about stabilizing revenue that's coming into state government, because that is a key and important component. The variation that we have from year to year as a result of the B&O tax has a huge impact on our ability to adequately fund programs that the government puts forward. But it also, that regressivity that Professor Spitzer is talking about has a profound implication for communities of color who are already incredibly impacted as a result of taxes, but pay a higher percentage of their income in taxes. And, if we have a state where low income people are paying a higher percentage and people of color are paying a higher percentage, there is fundamentally something wrong with that type of taxing structure.
Thank you, Dr. Blanford. Let's see, are there any other questions from the press?
There's one in the chat, I think.
Let's see. Thank you. Let's see. This is from NPI. For the attorneys on the call, Judge Brian Hubert concluded in his ruling that the new tax would be levied not only upon capital gains from voluntary transactions, but also in a number of scenarios where the sale or transfer of a capital asset would occur without any voluntary act by the transfer, e.g. transactions involving a minority shareholder, non-managing member of a limited liability company, or trust beneficiary. What did he get wrong? I'm going to look to my legal folks to answer that question.
Well, I think that there are a couple things. One is the principal characterization of an excise tax is whether or not it is based on a transaction. In terms of the voluntariness issue that he's raising, essentially stocks and bonds are ways to entice investors to invest in businesses and to make profits from the sale of those stocks and bonds at a later date. My dog is agreeing with me. But you can do that in a variety of ways, whether you purchase a stock directly or invest by being a minority shareholder or being a non-managing member of a limited liability company. It's all the same legal mechanism for drawing in investments into a business and getting people to do that by the possibility of a gain on a sale at a later date. So functionally, there is no, I think, legal difference in terms of characterizing this as an excise tax.
Thanks, Paul. And if there's any other questions, we can forego the raising of the hand and folks can just unmute and ask your question. All right.
I get one quick follow-up. Again, this is for any of the panelists. Just a question on if any of that research on other states' taxing regimes, if you found any evidence of so-called, flight of the wealthy when these, new taxes are instituted. One of the frequent claims you hear from opponents of taxes like this is, oh, if you, raise taxes, there's a reason that people found other businesses here, right? Like it's a low tax environment. That's what's, created this great economy. Can you just speak a little bit to whether or not those concerns are justified?
Andy, do you want to take that one? Oh, go ahead, Hugh.
Yeah, that has to do with the level of taxes overall. First of all, you don't see a ton of flights, people fleeing because of taxes. They tend to live where they want to live or where it makes sense from a business standpoint. Anecdotally, it looks like some people move from New York to Florida for a lot of reasons. And they say that it's partly because of taxes. But people, including people with substantial wealth, live where they live for personal reasons and as well as business reasons. And I don't think you see a lot of that. Occasionally, somebody will move off to some island that's a tax haven, but it's not huge. Was Andy going to say something on that too?
Yeah, I would just sort of reinforce where you were at, that this issue has been studied pretty thoroughly and has been pretty thoroughly debunked. That when you look at the high quality studies, in fact, wealthiest people are some of the least likely of people to move to any state. And it's not hard to think why. They're very entrenched in their communities. They've got business interests and family, and moving is a pretty big deal. And the research shows that taxes are just a very minor reason for people moving for any reason. And the real factors that drive interstate migration, which is pretty low overall anyway, are things like housing costs and the availability of good schools and parks and environment, things that taxes actually pay for. So yeah, this is a claim that is often made, but it doesn't withstand scrutiny.
Thank you, Andy. All right, any other questions? Going once?
Another question in the chat.
Let's see. Professor Lawrence said if the High Court agrees, this would become a tool for the ledge to take on other progressive taxes like income. Didn't you just voice the conservative stance against?
Well, first of all, thank you for promoting me to professor. So Hugh, I expect to get a call from you to teaching ranks. But putting that aside, what you're raising is a political argument that's been made by the other side. And this is not a political question. This is a state law constitutional question that should be decided by the Supreme Court on that basis. The political question of the consequences, sure, that should be fairly argued once the correct determination is made by the state Supreme Court about what state law requires. And that will be a very vibrant debate between the people of different parties and beliefs about what's fair taxation and what's not. But it doesn't have any play in terms of the legal case we're arguing next week.
Thank you, Paul.
I would just add again that the Supreme Court doesn't have to overturn any of its decisions in order to uphold what's before the court right here. And courts traditionally take the narrowest path, at least courts that function, healthy appellate courts, try to decide cases on the narrowest possible grounds. And I think the law professor's point in this case is that there are great reasons to hold that what the court did in striking down a broad-based income tax in 1930 was incorrect, wrongly decided, and a poor decision. But this isn't a broad-based income tax that affects the receipt of income across the board in terms of wages, salaries, and all the other forms of income. It's a narrowly focused transaction tax that is really no different than any of the other taxes that the court has passed upon and upheld over many, many years, because the legislature must have some fundraising tool to fund a modern state and a fair and equitable state. And that's what I think the legislature has done here. It'll probably pass muster, at least on those grounds.
And I'll add that the Washington Supreme, you take a look at the Attorney General's brief here. The Attorney General, in general, in cases like this, will not get into constitutional issues, and they will not urge any big constitutional change. They make a straight over tackle argument, which is the correct one, that this is an easy case. This is based on precedent, simply an excise tax, and it's as simple as that. And it's that kind of middle ground argument that is more likely than not to prevail here.
Well, thank you all to our speakers and our panel today, and thank you to the press for joining us. As you can see in the chat, we did put a link to the background memo as well as the correct titles and spelling of the names of all of our speakers who were able to join us today. If there are any follow-up questions, I believe you all have the press contact information for Heather, and she can help navigate those follow-up questions. And we hope to see you on our press conference directly following the oral arguments on January 26th at the State Capitol steps at noon. So we will see you then, and thank you again to our speakers. Have a great day.